item 14. And item 14 is docket number 42111. And I believe we have granted oral argument in this case. And I would ask at this point for those parties who are arguing to come forward. And we'll start with the complainant. So, if you would, I'm familiar with some people here, but not everybody here. So.
Good morning. This is Naveed Issa.
Good morning.
And I'm representing myself on my cricket field. Should I?
You go ahead and make your argument to us.
Okay. Well.
And the issue pending before us, I believe, is CenterPoint's motion to be dismissed as a party.
That is right. Right. That is right. And I will try to stick to that point as much as possible. But if I'm going here and there, I apologize in advance. Well, I've got this very first page of my complaint from the very first filing I did on this complaint back in 2013. And the very first paragraph talks about my complaint, what that complaint precisely was. It was about this 300% delivery charge on top of my electricity bill. So this sets the foundation of my claim. It was delivery charge, which includes the demand charge, and I was not given any disclosure whatsoever from CenterPoint when I was working with them for at least 2 months, back and forth, going to the field, talking on the phone, email, in a very good relationship, providing everything that the gentleman wanted from me. And I gave him, and the bill from the second month started to show this amount, which is 300% on top of the electricity charges on my bill, not the first month. So first month, as far as I've learned in this case, they're saying the first month my KVA was 10 or less KVA, and in the second month it went to 110 KVA. I'm not sure how they calculated it. They are saying their meter said it, but I have not added a single bulb in the second month of my inauguration of my field on the lights. So
can you pull the
sorry.
mic a little closer? You're relatively soft spoken.
I had presented this thing for your honors, so if you can review it. I'm not sure if I can hand it to you guys.
Sure, you can hand it.
Okay. Thank you. I've tried my best to summarize.
Mr. Janae, we'll have to file a copy of that in the docket, won't we?
Well, I think it's just I don't know that it's evidence as much as it's just like a demonstrative. But yeah,
wouldn't hurt.
Yeah, doesn't hurt.
Yeah, you can have this.
Are you sure?
Yeah, I'll have this.
So is this a summary of what you say
exactly.
you've alleged in your
Yes,
in your
it's the
complaint?
summary, so that you don't have to go through all of my arguments on this. This shows you the red line here that you see at the bottom. That is my basic complaint. That is almost exactly same as the very first page. So that sets the foundation of my claim. This is my complaint, right? This 300% of demand charges with delivery charge. On the left-hand side, you see the development of the case as it relates to Ambit Energy. And you can see how the ALJ, respected ALJ, found this law to be broken. And she said that it is broken by Ambit Energy. So that's why they are, in this case, responsible at this point. And this was information about demand charges. This was the triggering element of why they broke this law. And then the finding of ALJ. ALJ said in her order number 7 that they have breached this law. This is not being appealed here. So let's move to the right-hand side of this equation, of this thing, and then you see the information. The ALJ has ruled twice on this issue of this PUC Rule 2522 that talks about specifically on-site generation of electricity. On-site generation of electricity. So I could generate my own electricity, either through wind, through solar, or however I want to. And this was a legal information that was required to be given to me before they signed the contract with me to build the construction, to build the service, including the construction of it. And this construction, when they signed this contract, they had specifically mentioned the delivery charges. And this law talks about on-site generation. I'm arguing that on-site generation is directly related to delivery of electricity. if you do not provide me the information about on-site generation, your delivery becomes unauthorized. You cannot charge me for delivery of your electricity if you do not provide me information about on-site generation of my own electricity. That's what ALJ found twice. CenterPoint their appeal. I have read their appeal to the best I could. The only point they make there is like ALJ dismissed the issue on those points. They're not saying how many pages after pages they have submitted just on those two issues, including on-course finding. On-course filing, amicus filing was nothing but to address PUC Rule 25, 22, 5, and 7. And ALJ ruled again against that rule, despite their motion, despite on-course support, and despite AEP's filing in support, and despite the Commission's staff. And Commission staff has, I have to say that he has changed the position as ALJ determined. In the transcript, you will find it. I don't have the transcript because I think we had to buy that thing, so I had my own recording. And the ALJ used a word for the Commission staff, which is flip-flop. And I'm not saying it. I respect him a lot. So, okay, so, and then ALJ found twice that this has been broken, and this law is directly related to delivery of electricity, besides other things, besides the rebate, besides the construction alternatives, besides a lot of other things, renewable generation and a lot of things. I'm not counting them because they will argue that this is not related. And okay, if that's not related, would they argue that on-site generation of electricity is not related to delivery charges? And then on the next subsequent pages, I've given you the law. I mean, just for your quick reference, and ALJ's order, the abstract from ALJ's order by the date, and ALJ's order 11 on the date, and another one where ALJ found even MBIT to be responsible for that. I was including just CenterPoint for that law because I thought it is related to construction of facility. That's why it should be related to CenterPoint, and that's why I've argued from day one that CenterPoint bears more responsibility than MBIT. And
I'm leaning toward denying CenterPoint's motion anyway. So I would say we still need to listen to the rest of the parties.
I actually voted not to hear the appeal, but other parties, I suppose.
And I'm the one. I granted your motion for oral argument just because you are representing yourself, and I just wanted to make sure we work hard here to listen to people, everybody, but especially people who are represented by themselves. So
I appreciate that very, very much, and I'm very honored to be heard like this in this fine setting. So I can't explain how privileged and how happy I am to be sitting in front of you fine people. Thank you so very much.
The CenterPoint, does anyone from CenterPoint want to argue?
Yes, please. Good morning, Commissioners. Kate Norman on behalf of CenterPoint Energy. As Mr. Issa alluded to, at its core, this case is about the provision of information, specifically information related to demand charges. And as you know, a demand charge is a charge a customer pays that's directly related to the amount of demand that their facilities place on the system. So the demand charge compensates the TDU for keeping a certain amount of capacity available so that when a customer like Mr. Issa wants to flip on his sports lights, those lights will work. The case has a long and at times a tortured history. We've provided a chronology of the relevant events in the appeal. Initially, Mr. Issa proceeded with an informal complaint. This commission reviewed that informal complaint and determined that CenterPoint didn't owe a billing adjustment to Mr. Issa and that it complied with the commission rule that governs TDU tariffs. He then proceeded with filing the formal complaint, which of course is before us today. And his primary complaint is that no one explained the demand charges, so that when he received his invoices from his rep that included the delivery or demand charge, he was surprised by that. I think it's critical to note that throughout the judge's rulings in this case, she determined months ago that CenterPoint doesn't have a legal obligation, it doesn't have a responsibility to explain demand charges to an end user like Mr. Issa because he's the rep's customer. So the exchange of information as it relates to an end user is something that's between the rep and their own customer. The judge also ruled that CenterPoint billed AMBIT under the right CenterPoint rate at all times.
Well, let me ask you this question, and I know we're cutting ahead to the SOA hearing, but if CenterPoint does explain to the customer, if the customer specifically asks about what my charges will be, you know, because he's trying to make an assessment of whether he wants to have the work done at all, and CenterPoint does make representations, does that change things?
I think it could change things, but I think it's important to focus on the fact that CenterPoint is bound by the terms of its commission-approved tariff on file at the commission. Those words are the law that dictate the way CenterPoint interacts with anyone in the market. So the construction individuals that Mr. Issa worked with for 2 months to get the inline pole installed, those guys are not rate experts, to the best of my understanding.
But they're representing CenterPoint.
They are. They do, of course, yes. Okay. They work for CenterPoint.
Yeah, this case, it seems to me, highlights, at the very least, a gap in our rules, our customer protection rules. And it's part of a broader problem with demand charges. And in part, that's a problem in the effort during the last decade to simplify the number of rate classes and the like. And as a consequence, there's been pushback, as you know, parks and schools and churches, all that has. The judge in this case, and I, as I've said, I had voted not to hear the appeal. I think CenterPoint remains, at this point, a necessary party. Whether ultimately, I'm making no judgment on the ultimate determination, but and the last thing we need is another project. But this really does highlight I think, a policy gap. Because CenterPoint there's an argument that CenterPoint, for whatever reason, didn't convey the right information originally to the rep when the petitioner here was talking about what the rate would be. And I mean, I don't think anybody intentionally deceived anybody, but there was clearly a massive communication failure, and our rules don't seem to address that, and perhaps that's something that we're going to have to deal with to clarify it, particularly in the small commercial, in the class between residential and big box stores, where obviously they have people who know to ask the right questions.
And I agree with you, Ken. I think our market at times can be complicated, and I think disclosure is a really critical part of a competitive market, and I do think this does bring to light up an area that we can improve.
Right. Disclosure is the only thing that makes it work well. So I am also comfortable denying CenterPoint's appeal.
May I just respond briefly to Commissioner Anderson's observations? I mean, I think your questions hit exactly on the critical relationships that exist in this case and the market rules that do apply. So on the one hand,
I understand, but we're not deciding that today, what the facts are. So
certainly. And CenterPoint's motion is based on legal arguments anyway.
Understand.
So.
Okay. Given that, does commission staff or anybody from AMBIT want to address the commission?
Kay Trossel and Pat Zachary on behalf of AMBIT. I'm glad that you've clarified that, in fact, that the ALJ has not made any fact determination. Those were procedural matters, so there has been no finding of a violation. And we agree that there is perhaps a gap is the best way to say it in the Commission's rules about how these communications occur. Our interest is primarily in ensuring that it's clear that the way the market works is that while the rep is the billing agent, the TDU is the one that determines what the TDU charges are going to be applied to the Easy ID for Mr. Issa.
Good morning, Commissioners. Thomas Tynes with Commission staff. Just wanted to comment to Commissioner Anderson's comment. I think you actually hit the nail right on the head when you said that this highlights a gap in our customer protection rules. I think that was perfectly said, and it was an issue that we brought up at the summary decision hearing as well. Mr. Issa used the word flip-flop, so I, of course, have to respond to that. And it's only just to say that initially, in staff's initial statement of position, we wanted to see if any of the current customer protection rules required an additional disclosure from CenterPoint, given that they had this seemingly extensive relationship with him. And initially what I wanted to see is if Substantive Rule 25.22, which seems to refer to TDUs, says if facilities must be constructed, then they must give the customer an estimated completion date and an estimated cost for all charges incurred by the customer. My question was, did that just apply to construction, or did it apply to or could it also apply to demand charges and rates? We felt that CenterPoint responded well in saying that it seems pretty clear from the history of that rule it only applies to construction. And at that point, we were comfortable with saying that we thought the duty to communicate demand charges and rates purely rested with AMBIT. That's not to say that AMBIT had all the information that it needed in order to do so, but that was the reason for the flip-flop in staff's change in position.
I understand, but a customer, and actually it's a more important question at the commercial level. Residential, it's easy for a retail electric provider to provide a rate because they know what the residential TDU charge is. But at the commercial level, I don't know how a rep, or for that matter, a consumer, can decide on a particular contract unless they know the wires and poles charges. And the idea that you just say, well, your energy charge is this and whatever, and then we'll also pass through whatever the TDU charge is. Initially, at least, the utility provides, some information, or the rep asks for that, or if the customer asks. I don't know. This just seems whether the rule is being properly construed, and because it's really not before us. I've not looked at that. I haven't looked at the enacting order to see what the preamble says and that sort of thing. But just as a matter of common sense in our market, if it's not the law that information needs to be given in some way, then that's a huge failing. I mean, it's a glaring gap.
I agree.
Right. Yeah, I think that there are the rules, and then there are good business practices. And we will never, on this commission, be successful in writing a rule that covers every aspect and tells people how to treat their customers well. But when we have a really unhappy customer because of a lack of information, then here we are spending a whole lot of resources trying to get to the bottom of it. So it's
and I do think that when the customer goes to CenterPoint and asks for information about what the cost is going to be before the customer has a retail provider, our rules may not provide for this, and as Commissioner Anderson says, it shows a gap in our rules, which I agree with. I think it's a little bit of a different situation, and we cannot possibly predict every possible scenario that will come up. But I think it's up to us to evaluate and protect everybody in the marketplace. But a marketplace can't work without information. So with that, I will entertain a motion to deny CenterPoint's motion to be dismissed. Appeal. Okay, let me say this again. I said that wrong. I would entertain a motion to, yeah, that was right, deny CenterPoint's appeal.
So moved.
And I second.
Okay, thank you.
Thank you very much.
Okay, thank you.
And I want to apologize, Mr. Tynes. I used the word that came from ALJ, and there was a reason I had to use it because I know you've been so professional throughout, but I used that because you had supported. You had not supported MBIT's appeal, and here you had supported CenterPoint's appeal. So I wanted to kind of like bring to Your Honor's attention,
Okay,
you know.
Okay.
Thank you very much.
Thank
Okay,
you very much.
Thank you. Let's move on. Item 15.